Make sure that that's again. Okay.
Well, during the break, someone actually handed me a case from our Supreme Court from 2001, actually 2002, that says there is a right to a trial by jury in an ejectment action. It's not what the rule says. And even if there is, I urge you, do not ask for one. It'll be the stupidest thing you could do in a case. So please don't ask.
Let me mention this case. This does come up, and I get into almost an annual debate with lawyers at a different legal service agency about this, because they will routinely ask for a jury in an ejectment action brought against their client with the notion that the jury is less likely to eject their client from the property. So I understand why they're doing it. And in essence, the Supreme Court was basically saying, we know what the rule says, we understand. And so what I am left with this case is, you may get a jury, kind of like when a judge uses a jury on certain issues where the case is bifurcated, there's like split issues, one that the judge is going to have to decide and factual issues that the jury is going to have to determine. And that's in essence what that case suggests, that the jury will make the ultimate call either whether it's an appropriate relief. But remember, because of the form of order that you would need, a jury can't do that on a jury questionnaire. So ultimately the relief that you're going to get is going to go back to the judge. So just remember that, and Ed's point is well taken. If ultimately you're going to be counterclaiming to quiet title, which is typically what we're going to do in these cases, we're not asking for a jury. We want a judge to ultimately make that call.
What we're going to do is cover two more areas and then get back to the hypotheticals. So the first one is lease purchases, which often our VIP clients find themselves in. And then the last area, which we will briefly address, because as I said, there's a whole nother seminar on it, will be issues with estates. So Bobby, do you want to just take the lease purchase?
Sure. So let's talk about a lease purchase agreement. This is probably, based on my years of taking VIP cases, this is the most common type of quiet title case you're going to get for the VIP client. And what I try to remind people, and I've often had to remind the court about this, many of your clients, okay, cannot get mortgages, okay? They will not be able to qualify for a mortgage, okay? They also may not have bank accounts. So a lot of these things are concepts that may be foreign to you, but if you're representing VIP clients, you'll come to know this. A lot of them pay under these lease purchase agreements with cash, and they may or may not have receipts. I had many years ago a judge who is now no longer in the Court of Common Pleas. She's actually, I think she's on the Commonwealth Court. And I had a big fight on a hearing on a motion for default judgment where she said, Mr. Tintner, I don't understand. Where are all of the, your client's receipts? Where are the check stubs? Where are all the, I said, Your Honor, my client doesn't have a bank account. My client didn't keep receipts. And she's like, well, you don't have evidence to prove that there was a valid lease purchase and that the payments were made. I said, my client is taking the stand to testify. That's evidence. And you can believe or disbelieve my client. She's like, well, I guess you're right about, I can believe her. And okay. Point is, of course, that's what she testified to. She made payments. She had a couple of receipts. She didn't have all the receipts. She doesn't have a bank account. Why do we have lease purchase agreements? Because the idea is that the person who is leasing with the option to purchase or with the intent to purchase can't get a mortgage. They can make payments toward the purchase of the property, and they have a willing, in essence, seller who wants to do that. The difference between just a regular lease is that the person does get an equitable ownership in the property when they enter into the lease purchase. And what you often see with these cases is that they make all the payments. They are religious about making their payments and making sure, because they feel like this is how they're going to get their property and how they're going to own it. So 9 times out of 10, you're going to see a situation where they make all the payments, and at the end of the day, either the seller record owner disappears, they die, lots of complications. They leave the jurisdiction. They don't fulfill the term by giving them the deed. Maybe they don't have the wherewithal to get a deed or give a deed. And so the action to quiet title is used to basically enforce the purchaser's equitable interest in the property by converting them from someone who entered into a lease purchase into the record owner of the property. And you will often see these are the types of cases. I still think if we pulled up the current list, the majority of the quiet title cases would involve these types of lease purchase arrangements. The other sort of issue that we should talk about, we've alluded to it, we've somewhat addressed it. It is, by the way, VIP does a great training on sort of the estate element to this.
Let me just, if I can, on the
Sure.
lease purchase. Number one, appreciate that the VIP client is an easy victim for the bad guy in lease purchase arrangements, okay? So not that there's anybody out there that would ever try to take advantage, but they do in this scenario, because typically the VIP client doesn't have records, okay? So the bad guy thinks that they can get away with things, okay? Or they can sell the property to somebody else because they don't like the fact that your VIP client's paying $200 a month and somebody else is willing to give them $10,000. So it is a real problem where the VIP client is often a victim. It's also a critical fact pattern where the constructive notice of the rights of parties in possession becomes important. Because remember, your client, the lease purchaser, doesn't have a deed. They don't have a recorded lease. If you went down to City Hall, you wouldn't see anything at all that gives someone an indication that Mrs. Smith has any rights in that property, none whatsoever. So it's easy for somebody to claim, I'm a bona fide purchaser. I paid the Joneses $10,000 for that property. Your client didn't have any record evidence. Well, again, that's all fine and good. You make that argument, but that's not a winning argument when your client is in possession, because you're able to say, well, yes, there was nothing recorded, but the law says you're on constructive notice of what you could have learned by asking my client what basis they have for being in the property. And if you had asked that question, you would have learned that my client was in under a lease purchase agreement and was current on it. So don't feel that just because this is a race notice jurisdiction, your client doesn't have anything recorded, you can't lose. That's a key argument you may have to make in the lease purchase situation. All right, your states.
So we've talked a lot about Philadelphia having a lot of dead people owning property. We've talked about the complications in these cases involving estates. That does not necessarily mean that simply because there is a dead person, either on the plaintiff's side of the equation, meaning you are trying to assert an interest based on a relative who is now deceased interest in the property, or a defendant, meaning that the person who entered into the lease purchase or the record owner in an adverse possession case has died. That doesn't necessarily mean that the dispute itself will get litigated in orphans court. In fact, the majority of the title issues that we see, even where there is a dead person somehow involved in the chain of title, they are litigated typically in the court of common pleas. The issue is, do you have a proper party in interest? And we talked a little bit about this. You cannot sue the deceased heirs and beneficiaries of the decedent. You cannot sue the estate by name as the estate of, especially when no estate has been raised. You need to have a proper party, and the proper party in interest under the rules is an administrator or administratrix if the decedent dies intestate without a will, or an executor and executrix in the ideal situation where there is a will that needs to be probated, and the executor or executrix will then sit in the shoes of the decedent through the authority vested upon them by the Register of Wills when they take out the letters testamentary, or in the case where an estate needs to be raised, an estate is to be raised. So this is important because we see this all the time where people try to, in essence, take shortcuts. They don't want to, and I'm here to tell you, and Ed will, the process of opening an estate where there is no will in Philadelphia is time consuming. It's difficult. You have to provide notice to the interested parties. It makes your case that much more complicated. Okay. So I would urge you, first of all, to recognize that that may be an issue in the case, to potentially get help from VIP, or to get, in some cases, another volunteer to assist with the probate process, I'll call it. it really can complicate the matter, but I'm here to tell you that if it's not done correctly, you create a huge problem. If in fact you haven't raised the estate and you haven't sued the correct party, you may not be fixing the title problem because there are interested parties out there whose interests are not being protected, and you're not giving due process by giving, if you sue the administrator of an estate, properly and duly named, who has gotten letters of administration, you are in fact naming the decedents, correctly, meaning through the administrator on behalf of the estate, and presumably any heirs or beneficiaries who might have an interest ultimately in the proceeds or whatever it is, their rights will be protected through that process. If you don't use that process and you try to finesse it, even by naming, like, let's say all of the dead people, or I'm sorry, all of the heirs and beneficiaries of the dead person by name, technically you don't know, you may not in fact be properly naming all the correct parties. So I say that, and by the way, that process may require you to go, at least in part, in front of orphans court to deal with that. And again, one of the reasons we're kind of staying away from this, it starts to move away from the title issues themselves and starts getting into a whole different process. And I can tell you that VIP does a lot of trainings about this. There are a lot of lawyers who are far more experienced than Ed and me about dealing with this, but I can tell you, it's enough that I can recognize the issue and the problem and to know when I need to potentially raise an estate. I can use the case that I'm helping my associate with, actually, who's here. The problem is that the parties who have interest in the real property are now all gone. In essence, the record owner is died. Our client is in essence asserting an interest in the property based on her mother's interest, who is also now deceased. Mother did not leave a will. One of the decedent left a will, named the two kids, but now the kids are dead. So now there are missing pieces there, right, of who has the interest in the property and how can we in fact quiet title. And I'm telling you, it is almost like a law school examination question in terms of figuring out, have we named the right parties? Do we have the right interest? Very important question when you're dealing with these cases. You are going to see it come up. It will come up. It may be the type of case you say, I don't want this case, I want a different case. It may be something you think it's a challenge, or I have somebody who can work with me on this and help me with the estate piece of it.
So once you get the right party, it's the same case we've talked about all afternoon.
Right.
Okay, but it's just getting the right party. As Bob said, it's frustrating because to open an estate, you have to get a death certificate to prove that the person whose estate you're trying to open is dead. I will tell you, try to get one. Okay, I just had to get a subpoena issued by the Register of Wills to the Commonwealth of Pennsylvania to force it to give me a death certificate because they didn't think I qualified because I didn't represent the dead person. I represented somebody adverse to it. So it's a difficult process, but once you work through it, then you just follow through.
Let me mention, that's a really very important point about trying to get, in essence, the correct information. If there in fact has been an estate opened, you can get that file. You can get it from the Register of Wills. So that actually may be very helpful in terms of identifying people and who have the interest in the real property. It is, I'm just going to tell you, it's a challenge, but it is no different. Let's say you represent somebody who's been injured in a personal injury case and they die before you've been able to file suit, or they die while you're in the middle of a lawsuit. Folks, you got to do the same thing. Now, if you're the plaintiff, you have obviously a strong financial interest in raising the estate. But what if the defendant who caused the injury is now dead and nobody wants to raise an estate, either because the estate has no money potentially, or they don't want this lawsuit, being filed or continuing? Same thing, folks. You got to find somebody, you got to raise the estate. It's no different. So I'm here to say, getting the proper party and interest goes far beyond sort of the title issues and whatever. It's just, you're going to see it much more frequently just because of the nature of tangled title in Philadelphia.
Practically speaking, do you open up the estates of the deceased people if they're not your client?
Yeah, well, and again, this is often the problem you
Yes.
have, okay? The problem you have is that no one in the family believes there's any value in doing it, nor do they want to be involved. Okay, so if they're not willing to do it, you have two choices. You either say, well, I'm done, or you take advantage of the fact that there's a list in the probate code of people who are entitled to raise estates. And you get pretty far down the list before you get to basically a claimant against the estate or quote unquote any other fit person. So if you want to move forward, you have no choice but to open the estate. You hope that by doing it, you're going to have to give notice to the Commonwealth. The Commonwealth will say, we'll do it because we want our money. If not, you may have to have a client representative who is in essence the representative of the estate and the plaintiff in the case, which raises some real complicated questions from an ethics standpoint. I actually have 3 cases where these were tax sale cases, but I had to open an estate for the defendant by having my client, the plaintiff, appointed as the personal representative. And you jump through a million hoops to get there, but you can do that. But it carries with it an obligation, once you're appointed the administrator of the estate, to do all the things you're supposed to do to administer the estate, which is filing an inheritance tax return, filing inventories, and doing all kinds of things. So again, it's a nightmare. It's a subject of another seminar.
Let me make one point, because you alluded to it, and I handle the ethics hotline for the Philadelphia Bar Association. This does become a critical issue if it's your client who passes away or you're representing the interested party from the client. You need client authority. So in many cases, you may be required to raise the estate so that you have a proper client who substitutes in the shoes of your former client. So I say that again, just be aware of it. It is very important. You may think you have the authority to make the decision not to pursue the claim. But if you don't in fact have a proper representative of your former client, you may be making that decision without appropriate client authority. So again, it can be a very difficult thing. I wish I could say, oh, go to one of these 10 lawyers. They'd be happy to raise the estate for you. Unfortunately, there are fewer and fewer lawyers out there who want to do this.
Let me raise one other issue, and then let's jump back to the hypotheticals. And I hope that as we go through them, you'll say, yeah, you know what? I now know what I do. Title insurance. If any of you have bought property, you probably, I hope, bought a title insurance policy. And that title insurance policy provides tremendous protection for you if there's any defects in the title to the property. If you have a loss as a result of it, you can probably collect under the title policy. And if there's a problem where someone contests your title, the title company hires a lawyer like me and pays me to fix the problem. VIP clients don't have title insurance, but when you get an order, okay, declaring that they're the owner of the property, one of the things that you need to advise them is I would strongly urge you to get a title insurance policy. Because now not only do you have a court order fixing the problem, but you have a title insurance company that is going to stand behind that title if there's some argument in the future that there's a problem with the ownership, there's a problem with the title. I think we may have some money that's available under the title fund to pay this. So I don't want to spend a lot of time talking about it because it'll take away from the hypotheticals, but just keep in the back of your mind that once you fix the problem, if you can get an insurance policy that confirms you fixed the policy, the problem, that's the best of all worlds for your client, because there's a good possibility that once that title company's on the hook, when your client tries to do something and there's an issue, that title company may say to the next title company, don't worry about it. We got it covered. And you may get the deal to go through that otherwise wouldn't have gone through if there wasn't a title policy. Just keep that in the back of your mind. Recorded order, and then suggest to your client strongly after speaking with VIP about what might be available to pay, because your client probably doesn't have the funds to pay for the policy, that you get one. All right, so let's go back to the hypotheticals. Number one, we had the Smiths who were married. If you remember, they were divorced. Mr. Smith obtained the divorce decree down in South Carolina. He was supposed to sign a deed conveying title to the property to Mrs. Smith, but he never did. Okay, Mrs. Smith is now looking to get a mortgage on the property. She can't do it because guess what? Both Mr. and Mrs. Smith are in title, And you might imagine when she calls Mr. Smith and says, hey, will you sign the note and mortgage? Mr. Smith is going to say, yeah, sure. Okay, so what do? Well, we're going to file a quiet title action. We're going to file a complaint on behalf of Mrs. Smith against Mr. Smith. We are going to lay out that they acquired the property at a particular period of time as tenants by the entireties, that there was a divorce proceeding that took place in which a court order was entered declaring that your client was the owner of the property and that Mr. Smith was to execute a deed conveying title to the property, that Mr. Smith never executed the deed, that you've been in the property, and that you would now like the property, the title to the property quieted in your name. Okay, those are the facts. You'll serve Mr. Smith. If you can't find him, you'll get alternative service, and you ultimately will end up with a judgment. What you don't want is to put in the order, please, judge, in Pennsylvania, have Mr. Smith sign the deed he was supposed to sign in South Carolina. Okay, he ain't going to do it, and you're just prolonging and adding a total unnecessary step so that the judge in this case can say, based upon the pleadings and the evidence, Mrs. Smith is the owner of the property. She's confirmed as the owner. Mr. Smith has no right, title, or interest in the property. And Mr. Smith is barred from asserting any claims, blah, 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 blah. So you'll end up with an order that gets Mrs. Smith what she should have gotten 20 years earlier when Mr. Smith was supposed to deed the property over to her. You'll get the order. You'll get a certified copy of the order. You'll take it over to the Department of Records and you'll record it. Mrs. Smith hopefully is still in a position where she can get the mortgage. So relatively simple. You didn't have to get into a lot of different legal theories. You're just saying a judge has already decided that I am to be the owner of the property. Pennsylvania judge, please confirm that. Okay? Second hypothetical is the situation where Mrs. Smith has been renting the property. She paid $3,000 down. She was told once she paid an additional $2,500, she would be given a deed to the property. She makes those payments. The Joneses, instead of giving her a deed, give her a bill of sale. Not unusual. Bill of sale as opposed to a deed. And a deed is never recorded. Mrs. Smith learns about it again when she gets married. She wants to transfer the property from her own name to herself and her husband, and she can't do it because she's not the record owner of the property. What do? Really simple, right? We're going to file a complaint. We're going to file a complaint on behalf of Mrs. Smith against Mr. and Mrs. Jones. We're going to lay out the facts of the case, that here was the agreement that the parties had that conditioned upon paying the $5,500. The Joneses were to execute a deed of the property. They never executed a deed of the property. Here's proof of our payments. We would like an order confirming that our client is the owner of the property, having fulfilled her obligations under the agreement between the parties. Again, you don't want to ask that the court issue an order forcing the Joneses to sign the deed. They're not going to do it, or if they do it, it may be that they don't do it for another 90 days to 120 days after you got your order. It's a relatively simple fix. Again, assuming you can prove what the deal was and assuming you can prove that the money was paid. An argument will be made that the deal's not valid because of the statute of frauds and you don't have an agreement in writing. You can get beyond all that through some of the exceptions in the statute of frauds. But again, you're using the same process. You're using a quiet title order to confirm your client's ownership of the property.
Let me make one point on these orders that we're talking about. In Philadelphia, at least you used to be able to do it, I'm pretty sure you still can. You can record the order as a deed. So what we were talking about in terms of not using a deed of confirmation or asking the commissioner of the Department of Records to sign over an actual deed, the order can be treated as a deed. It's just a higher fee, but VIP usually, we get that fee waived anyway, so it doesn't matter. It'll be recorded so that if somebody were to do just a deed search, they will find your order as if it transferred property or corrected the title problem. So just keep that in mind. That's a recording issue, but it's something that can be overcome as opposed to just recording the order as an order where you pay less and it's not treated as if it's a full transfer of title. So just keep that in mind.
The third scenario was the lease purchase arrangement where your client has been making the monthly payments, ultimately paid the full $10,000 price, stopped making payments, and many years have passed since then. Your client was trying to get a mortgage, couldn't do it. Again, the same situation. You're going to file a quiet title action in this particular scenario. You're going to lay out the fact that your client had this agreement. If you're going to use an adverse possession argument in order to prevail, remember, you can't use any of the time period when your client was under the lease purchase payments. Those would have been times when your client was in possession of the property with permission of the record owner of the property. So you'd have to be sure you have either 10 or 21 years beyond when the time period ran out. But it's the same claim. It's the same relief that you're asking for. The complicating factor that we put in this hypothetical is, remember, title was still in the name of Mr. and Mrs. Jones. Well, what if during the time period when the property was still in their name and you were in the property, a judgment was entered against Mr. and Mrs. Jones? In Pennsylvania, a judgment against an owner of property, constitutes a lien on that property. So the minute Mr. and Mrs. Jones were found to owe $15,000 or $14,000 to a credit card company, that judgment creates a lien on any real estate they own in the county where the property is located. So now you've got two problems. You have a problem of trying to get your title free and clear of the Joneses, but you also now have the ABC credit card company that has a lien against your property. So if you ignore that credit card lien, after your client gets title to the property, the next thing that's probably going to happen is she's going to get a letter from a collection lawyer that says, if you don't pay us the $14,000, we're going to expose your property to sheriff's sale. And if you haven't addressed it in the complaint, then you're going to be embarrassed because now the client's going to lose the property. Now, what argument do you have? I will preface this by saying it's not a strong one, but it is probably the only argument that you have. And that is to say that your client was in possession of the property under a fully complied with lease purchase agreement at the time the judgment was entered. And that if an inquiry had been made of your client at the time the judgment was entered, the judgment creditor would have learned that the Joneses no longer had an ownership interest in this property because you had fulfilled your obligations. That's an argument. And I underscore it's an argument because normally that applies to people who take interest in the property through deeds or mortgages or things like that. I'm not aware of a case where that's been successfully used against an involuntary lien that arises as a result of a judgment being entered, but it's worth rolling the dice and taking a shot. Because if not, you have no other legitimate claim, unless you can attack the validity of the judgment itself. But for purposes of this hypothetical, we're assuming the judgment is valid.
You can, listen, the practical reality is you can probably get rid of it by limiting the relief that you're seeking. You're not actually, you don't want to attack the validity of the judgment per se, because then you're going to get their attention, right? They're really going to fight on that. If you basically say it should be stricken as a lien on this property, because by the way, Mr. and Mrs. Jones actually live in Montgomery County, here's their address. I mean, typically what you'll see is most judgment lien holders who have an in personam judgment are not interested in going after record owners after the fact. They're interested in getting paid by the debtors, the judgment debtors. So you may actually, and what I typically encourage VIP volunteers to do is try to reach out to these companies before you sue them to say, listen, just as Ed said, this judgment was entered when they really didn't have an ownership interest. They were still the record owners, but in fact, they sold the property, under a lease purchase, blah, blah, blah. I've had success with them just basically saying, we're not going to pursue it.
And again, the key point of this being, had you not done a title search and had you not reviewed it ahead of time, you would not have known that this was a problem. Okay? If for example, you found out the judgment existed and it existed arguably before your client entered into the lease purchase agreement, then you'd have no argument at all to try to defeat it. You'd have to say to the client, well, look, here's the problem you have. We don't have a basis to defeat this. We can call them and see if maybe we could try to negotiate a release, as Bobby says, of that judgment from this particular property. But if we can't do that, I would suggest, as terrible as it sounds, you find another property. Okay. Let me do the unsatisfied mortgage. Again, not uncommon, where they take out a mortgage on the property. Mortgage has been paid off long ago, and the mortgage still exists on the property, and you need to get it satisfied. Well, again, the quiet title rule says one of the things you can do is to compel the satisfaction of a lien on the property. So you would bring a case against the defendant mortgage company. Again, I wouldn't ask them to satisfy the mortgage. I would ask the court to enter an order declaring that the mortgage is satisfied, that the mortgage is no longer a lien on the property, and that your client owns the property free and clear of the mortgage. Okay, again, simple relief. It's called for in the rules. Where it becomes complicated is that oftentimes the mortgage companies aren't around anymore. Okay, it's a mortgage from the 60s. Or arguably the mortgage company's still around, but they're a part of what's called the MERS system, where they're still around, but their mortgage has now been assigned 17 times in the MERS system, where none of those assignments are of record, but they don't own the mortgage anymore. That becomes more complicated. But again, back to the concept of knowing who you're suing, you have to figure out the right company first. And secondly, if you found the right company and they're not around again, you get into the situation where you need an alternative service order, okay, where you prove to the court that they haven't been around, judge. Now, that may be one where a judge requires publication as opposed to posting, but it's not an insurmountable problem if they're not around. It just makes it more difficult, okay? The last one, and then I have to run because I have a 2:30, is the estate problem. And that's the one where you have Mrs. Smith living in the property with her grandparents and her mother. Her grandparents are now dead. Her mother is now dead. And she wants the quiet title to the property in her name. As you can see, there are some problems here. There's a question of how many estates do you have to raise?
Right.
Do you have to raise an estate for the mother? Do you have to raise an estate for the grandmother? Is there the possibility that not surprisingly, your mother had another couple of kids. And oh, guess what? They don't like the fact that mother gave you that house. So you've got to sue your brothers. Or you got to figure out, does mom have more brothers than I know about? And again, it's not uncommon that you have multiple fathers, possibly multiple children. You got to figure out who they all are. Okay, because again, the goal, not to beat a dead horse again, is to fix it the right way. And the only way you can fix it the right way is to figure out who the right parties are. So you may have to bring suit against a number of estates, and you can't do that unless those estates have personal representatives. So again, it's complicated. It's not necessarily you throw up your hands and say, I can't do it. If I were you, and the last thing I would do before I run is urge you to take the case, that would not be one of the cases you take. Okay?
Maybe not first.
Pick one of the other cases. And again, please, if you appreciate at all what Bob and I did today, and if you appreciated all the plight that the VIP client, we all take for granted that we go home at night to a house that we own. And we all take for granted the fact that we go home that we don't have to worry about somebody threatening to throw us out. Well, guess what? We're fortunate, okay? That's not a situation. And I will tell you personally, there's nothing more gratifying than to successfully handle one of these cases where you've protected the single most valuable asset that this VIP client has. I would also say, just very lastly, although I said lastly 3 times, this is a tremendous booklet that VIP has put out. We put it together very early on. Bobby and I worked on it. VIP has done a tremendous job expanding it. It'll answer a lot of questions for you. It's a tremendous tool that you can use. Please take a case, and then I apologize, but I have to run for a meeting. Okay, thank you.
So let's, in the last sort of segment, we're going to answer some questions. We're also going to talk about VIP's role in all of this and how they can help you. Mike, if you want to come up here, because there'll be some stuff that, but let me build on one thing that Ed said, because it does lead into this part of the discussion, which is that you are dealing with clients who this may be their single and only asset. And it may not be, it may be something that isn't defined under the law as their asset. So that is what you're hoping to them to accomplish. I will also tell you that having been a VIP volunteer for probably 30 years and having taken a number of different types of cases, the reason I typically take these cases, this is not the type of case that your client's going to disappear on you, okay? So this is not a case where the client is not that interested. The best example I can give you is where somebody falls on their property and they have no insurance. And they basically feel like they're judgment proof and they don't really have a stake in the game, right? You still have to defend the case. You still want to protect their interests. They may not cooperate. They may not want to sit for a deposition. They may not be interested in what you're doing, even though you're really helping them in the long run, because you don't want them to have a judgment against you, particularly if they don't have liability. The difference is in these cases, the clients are involved. They will be responsive. They care about their property. As Ed said, the typical case comes to you because they now have a situation. They want to make repairs. Somebody's threatening to eject or evict them. There's some issue. They understand that they need help. They need a lawyer to do it. They're going to participate. They're going to help you, which is a great reason that you want to take this type of case. I would agree with you on the last scenario case, the estate case. If you go through the estate and probate training, if you feel more comfortable or you have a background in that, it may be a case to take. There are lots of different options. What I always try to suggest as a mentor in these types of situations is, why don't we see if we can get 2 different volunteers, maybe a volunteer to help with the estate piece, a volunteer to help with the title case. I have partnered with different lawyers over the years, some of which on cases I've started as a mentor and then thought, maybe they need some help with the trial, if there is a trial. So lots of different opportunities. The other thing about it is when you read, so I'll let Mike do his spiel on how you would, in essence, identify a potential VIP case. I do just want to talk about a couple of things related to that. Not every one of these cases is going to require a lot of litigation experience. So keep that in mind. A lot of what you may end up doing is drafting. So if you have a transactional background, it may be an appropriate case. Obviously, if you have to file an action to quiet title, you are going to go into court. Most of these cases, but not all, most of the cases are resolved by the motion for default judgment. So a lot of times you're dealing with a totally disinterested defendant. So keep that in mind. Obviously, that can potentially shorten the time frame, can potentially shorten the amount of actual courtroom you have to deal with. In some cases, you get judges who will review a motion for default judgment on the papers. You never have to go into court, but I don't want to make that guarantee. A lot of the judges will require at least a hearing, okay? So he's not here anymore, but I had one of my colleagues who had a motion for default judgment and the judge scheduled it as if she was scheduling a normal rule hearing. They went in, she wanted to hear a little bit of an argument about what the case was about. She wanted to hear from the client, not in a formal direct, but she wanted him to say why he was there, what happened to him, why they were seeking this relief. She entered the order. That was it. That was the trial, so to speak. That was the hearing on the relief. So it really depends on the type of case. We've also had cases, I've had cases that have gone to full-blown trials. Jackman on one side, quiet title on the other, lots of fact issues, right? You have to have a judge decide the case. So it really depends. And you should base your sort of interest or your, decision on which case you take based upon what you are interested in doing, okay? You may recognize right from the start, if it's a case that comes in because an ejectment action was filed, you're gonna have to counterclaim for quiet title, but you have a lawyer on the other side, that there's gonna be more full-blown litigation. So just think about that depending upon your comfort level. I'm gonna turn it to Mike to talk about sort of the process for getting cases and some of the support that we've alluded to that VIP can provide. And then I'll sort of conclude by talking about the Tangle Title Fund.
Okay, cool, you beat me to it.
Yes.
Taking a case, as Bob had said, there are lots of different opportunities in many different ways. We have a case list that we have online at all time. We also mail it out monthly. You're welcome to peruse the website. You're also welcome to just give me a call and chat it out. Like we have so many options that it can be overwhelming to look at the case list and you may say, I don't know, this is what I'm looking for. I mean, we have some volunteers who are okay just accepting whatever we send them.
But it's all great.
Me too, me too.
Our goal is not to, as Ed had said, give you a case and leave you in the wilderness. Our goal is to give you a case that interests you, that provokes you, and that can help a client that you feel is going to fit either your skills or the skills you want to develop. What would happen when you take a case is that we would send you your conflicts, however you or your firm runs those conflicts. That's up to you. I don't care. Then conflicts would get cleared. Afterwards, we would send a case file. The case file would include home ownership cases. It would include everything that you would need to begin getting this ball rolling: the deed, the chain of title, the Office of Property Assessment, any supporting documents that we may have collected, a lease purchase agreement, receipts, a full list of case notes to support the narrative. And if in the event there is some form of probate, we would also include as much information as we have on the decedent and any heirs.
Let me just make a point about that. I would love every one of my clients, paying clients, who came in the door with that kind of packet. And I'm not just saying that. It is wonderful to take a case from VIP and have it, in essence, all laid out. Don't forget, the case has already been screened, so it's already been reviewed to make sure that the client meets the eligibility requirement to get pro bono legal assistance. But then VIP does an excellent job. Their staff attorneys really understand the legal issues, and they're dealing with them so frequently that they have pre-screened the case, at least to get a review of whether it's appropriate to send to an attorney for the relief. So a lot of all that legwork is done for you. And a lot of the questions that you would typically have when you first sit down with a client, a lot of them are answered there in the case notes. That doesn't mean you shouldn't sit down with your client and go through all the same stuff and make sure you have everything. But it is really nice to have it all sort of laid out for you.
Yeah, and I mean, that goes to a point in a moment, but we would then order a title report that you would be able to use. And as Bob and Ed have repeated, the importance of the title report exceeds just the information that you could glean from it. It goes to figuring out and resolving the actual title issue. So all of this together would be something that you would have. Afterwards, we have an immense amount of resources. We have me, if you want to continue to speak with me as a support. We have other staff attorneys and my supervising attorneys who can act as support. We have templates. We have mentors. There's generally nothing that we're asking you to do that reinvents the wheel. You may have to do something novel and fun, but you generally will have a good idea about that in advance. So our goal, again, not to leave you in the wilderness, to give you as much support as possible. As you're progressing through these cases, you'll learn, hey, maybe I have costs involved. Now, if you're filing a quiet title case, all of the costs for our clients would fall under IFP and forma pauperis, which means that they wouldn't have to charge anything in court filings, but there might be, God forbid, advertising, publication costs. There could be title insurance costs at the end. There might be transfer taxes in the event that a deed gets recorded and the final order does not ask for the waiver of transfer taxes. When that happens, we have a marvelous resource available that.
So for those of you that don't know or have never taken one of these cases, we have an organization called the Tangled Title Fund. It receives grants from different entities, including, by the way, the city of Philadelphia, which I always find ironic because most of the money is going in some form or fashion back to the city of Philadelphia. It doesn't matter though, because what the Tangled Title Fund does is it provides a resource to cover a lot of the expenses associated with putting title into the name of your client. It's wonderful. I would urge you, 90% of your cases, you're going to want to file a Tangled Title Fund application to get your client, in essence, approved. I always tell people, do that early on when you're meeting with your client, get the information, file the Tangled Title Fund application. And then as disbursement requests or issues come up where you need funds from the Tangled Title Fund, you can apply and just file it. You'll all have already been approved. Hopefully, you just file a simple disbursement request with the backup for what the request you're seeking. So talking a little bit about what they will cover. Remember, in almost all VIP cases, you want to check the box now. You used to have to file a petition. Now all you do is say at the end when you're filing your complaint, informa pauperis, make sure you check that box. Once you check that box, you will not have to pay for a single motion. You will not have to pay to commence the action. You will not have to pay to serve the defendants. Very important. I also use that. I bring it down when I go to get my certified order at the end. The city of Philadelphia, especially the Common Pleas Court and the Department of Records, do everything possible, I'm telling you, to help indigent clients. We are, in essence, helping them too. So don't forget that. Because by taking these cases and resolving these issues and doing the recordings and cleaning up these title problems, we are, in fact, helping not only the departments, but also, obviously, other Philadelphia constituents who live here, taxpayers, people who do pay all of these charges. So I'm just telling you, it's worthwhile, but take advantage of the free things so that you can use the Tangled Title funds to pay for things like deposition transcripts, service expenses like posting and things like that. Often real estate taxes, they won't pay interest and penalty, but they will pay. And what is the grant up to now?
It's $4,000 available for all applicants, and up to $5,000 if there is excessive transfer taxes or inheritance taxes.
Which gets to the second piece, which is the estate piece. The Register of Wills does not cooperate. So every single charge that you would normally have to charge for any paying client, the Register of Wills is going to force you to collect. So probate filing fees, obviously inheritance tax, which is a different issue. But the Tangled Title Fund can help you with that. So you can often apply for the grant. The Tangled Title Fund has a committee that reviews. I used to be on the committee. They review the applications, make sure that it's a valid and legitimate interest in title, that the property is worth conveying title. So this is something as the lawyer you should be doing anyway, but the Tangled Title Fund will make sure that they're not giving you money that's ultimately going to be lost because the property is going to sheriff's sale or something like that. And then they will actually review the disbursement requests, and they will reject things like filing fees if you didn't ask for informa pauperis or you're trying to basically charge for a recording fee that they know that they can get for free. So they're pretty strict, but once you get into what's covered, it's very worth to your client. It's such a benefit to have your client utilize not only the fund itself, but just the resources available through the Tangled Title Fund. Definitely apply. I'd apply early in the case because if you do need an emergency disbursement request, better that you've already been approved, your client's already been approved, and all you have to do is ask for the disbursement request. They will require backup. They will reimburse you, by the way. If you are willing to front the money, the Tangled Title Fund will reimburse you if you can demonstrate, obviously, that you paid the expense or fronted the expense.
I will say I am legally obligated by the city of Philadelphia to say that we cannot guarantee reimbursement. However, if you ask me, I will do everything in my power to make sure you get reimbursed.
And what about service of process?
So this is why we don't ask for publication.
Well, I mean, like you send a process server out to somebody's house to hand service.
Yes, they will. But what I've often found, having done this for many years, tell your process servers that you're handling an indigent client and you're providing pro bono legal services. Often they have a reduced rate. They will give you a much lower rate. So always worth asking. Worst thing they say is no, and you ask around and you find that listen, these organizations love to also say that they are providing assistance to indigent Philadelphians. So it's worth asking when do the same thing.
Can you give us a list of?
Well, we can find out which ones
Yeah,
we've used, but certainly with deposition services too.
You can also just reach out to me in certain events. We have a Rolodex, just like we have a Rolodex of all of you. We have a Rolodex of all of the different volunteers and other services that provide some level of if not pro bono, then low bono. So reach out on behalf.
Don't be shy about asking for help.
Mm-hmm.
Okay, this is one of the most important points I want to make. It is a lot easier for me or another mentor to come in and help you with the case. Maybe toward the outset, but maybe as you're litigating it, until you come to me at the end after something's already happened and it's much more difficult to fix. So I say that because I offer my services if you've never looked at a title report, okay, and you want help just going through it for the first time. Pick up the phone, email me and say, can you go through the title report with me? I'm happy to do all of that, okay? It is worth my time and effort. It's worth your time and effort if you want help on something. If the first time you've ever done a complaint to quiet title, you want somebody to just take a look at it, I'm happy to do that. There are mentors who will do that. People at VIP will do that. I know we stress this, but I really, Ed had some things that he said are the most important things to remember. My most important takeaway from this process is make sure your wherefore clause in your complaint gives you all of the quiet title relief you want, and the order matches that. It is not necessarily a perfect process, but do your best, because if you miss an important step, one of which could be, I'm just going to give you an example because I had to deal with this recently, where you didn't put in your wherefore clause or you didn't put in your order quieting title that you're asking that the court forever bar the defendant from asserting any right, title, or interest in property. Arguably, your quiet title relief is not complete, right? Because then you potentially have somebody out there who has an interest. And the other thing with the title insurance, if you're gonna get title insurance, and by the way, the Tangled Title Fund will pay for that, send your proposed form of order to the title company before they offer to insure it. Make sure, I don't do that anymore because I've done for 30 years, I've worked for title insurance companies. They typically were coming to me saying, is this order something we should insure? So I'm pretty comfortable that our proposed forms of order match what they're looking for, but it's always worth an ask. You want to make sure that what you're doing, if you're fixing the title issue, and now you've conveyed title to your client and it's done, you want to make sure that they then can sell the property or behest the property to a relative, and that ultimately that relative can sell the property, and that the buyer of that property somewhere down the line, 25 years from now, is going to be able to get title insurance. Otherwise, they may walk away from the deal and you're left with a property that you can't alienate. So just think about that. That's the point of title insurance. If a title insurance says, yep, I'm willing to insure this transaction, your client is protected. They have title. There's a problem or a defect later, the title company is going to come in and fix it, not another lawyer. So just remember that, worth the time and effort to maybe, if you're going to get title insurance, you anticipate asking the Tangled Title Fund to cover it, send the proposed form of order and say, will you insure this at the end of the day if I get this order entered? Worth your time and effort. Or you can have one of the mentors take a look at your order and follow your proposed form of order. We have a couple more minutes. I would like to open it up for questions because I know we've covered a lot of material. Anything is fair game, so ask whatever you'd like. Go ahead.
So either you or...
Could you tap the mic?
Oh yeah, you have to tap the mic. It'll turn green. Yep.
Thank you. So either you or Ed spoke earlier about using Jane Rose or John Doe's as defendants. Can you talk about what scenarios you would do that in?
Sure. So, and I don't want to make this too complicated from the real estate end. There are situations where someone may have an unasserted interest in real property, okay? That's typically, by the way, we didn't get into the types of deeds, because typically you're not going to have to worry about that. But if you've ever heard the expression of using a quitclaim deed, that's what a quitclaim deed is designed for. It's not, people misuse it and call things that should be warranty deeds, quitclaim deeds, where they're conveying title from the person who's actually the record owner to the new person. Okay, that is not the purpose of a quitclaim deed. A quitclaim deed is where there is some unasserted interest in real property out there, because an estate was not properly raised somewhere along the line, because there was a defect in the estate, because there was a defect in the chain of title, a wild deed. Again, I don't want to try to make this too complicated from a real estate. What's a wild deed? A wild deed is Mike conveys 123 Main Street to Bob. Okay, Bob now has the property. Bob conveys it to somebody else. Mike, just out of the blue, when he no longer had an interest, conveys the property to somebody else, okay? None of that is valid. That is outside the chain of title. That is a wild deed. But if we're gonna quiet title and we're gonna fix the problem, we're probably gonna ask the recorder to strike that wild deed, right? But because of the wild deed, maybe there's somebody else who's now claiming an interest. It's not a legitimate interest, but you know about it, okay? And you know it's out there. And if the title insurer does the title search, they're gonna see the wild deed if we don't get an order striking it. And then there may be another deed following that. That is potentially the John or Jane Doe, if you don't know their name or you don't understand, or the deed, you assume there's a deed out there, but it hasn't been recorded. You may want to use that process. It's not going to be very frequent. And just remember, under the rules, as I understand it, as they've been amended, you can name a John or Jane Doe, but ultimately, when you come into contact, whether it's through the discovery process or whatever, you have to substitute in the real names anyway in order to validate the fact that you name these other individuals. I am not recommending that you do that in the typical case unless there is something on that title report or something out there that raises a concern and raises an interest. I have seen wild deeds in some of these cases. I've had to sue these other parties, but it's very rare, very rare. Other questions? Mike? Oh, we didn't talk about the transfer tax, which go ahead and then I'll deal with that.
We can tie it in. Adverse possession case where, and it's your favorite kind, the tenure. But we actually got a final order. The problem is that we had it against an active person who filed an ejectment case. They are now appealing that to Superior Court. Should we record the order with a deed of confirmation now?
Well, this is a good civil procedure question in general. Did they file a motion to stay?
No.
Record it. I mean, the bottom line here is, listen, the rules of civil procedure and the rules of appellate procedure still apply. When parties file appeals, right, if they file an appeal from a judgment, if they do not file an application to stay either with the trial court or the appellate court, you're free to execute. Now, you run the risk that you get that money, and ultimately if the appellate court reverses, although there's a great argument that if you get paid in full, it becomes a moot issue, and you may get, I have won on that issue, at least before one judge who heard it, because remember, if you go to the Superior Court on a motion, you don't necessarily go to the merits panel. You'll go to an individual judge, and I convinced a judge that the appeal was moot, and they in fact mooted it. So I raise that only because it's the obligation of the appealing party to seek to stay the relief. It's no different than if you filed an appeal from an injunction or any other form of equitable relief, right? It's your obligation. If you don't do it, I would go ahead and do it. And then I would say, I'd actually file a motion to quash the appeal. They never sought a stay. We recorded the order. The interest has been conveyed.
The order itself it's for adverse possession. The order itself asks for the waiver of transfer taxes, which I think is what we wanted to talk about.
Yeah, I did want to ask one question
Sure.
on the final order. Did they ever oppose? They didn't file an ejectment
So
action.
it was actually, let me correct myself. It was on a motion for judgment on the pleadings. And
Did
that's
they
what
oppose it?
They did oppose it.
Okay. Otherwise, they waived it, but okay. Okay.
No, they didn't oppose it. Then they had a motion for reconsideration.
They've waived it. They've waived all these, moved to quash the appeal, record the order. The appeal will be quashed. They waived it by not. Reconsideration in Pennsylvania, for those of you, that does nothing to help you. I mean, you may, unless it's granted. If it's granted and they vacate the order, you got something to work with. But if they don't, that's it. It doesn't toll the appeal period. It doesn't stay application of the order, and it doesn't unwind the waiver. If you file a motion for default, by the way, it's a good point. No response, you get a final order, and then somebody tries to reconsider, tries to file an appeal, quash the appeal. It's all been waived. If they didn't actually oppose the motion, they have waived any request for relief. You cannot go to an appellate court in Pennsylvania and ask for relief that you did not first try to get from the trial court, which includes asking the court to deny the motion in the first place. So just remember that. That does come up. Now, the transfer tax. We have a couple minutes. I'll just mention this. So largely because of the VIP setting, we have asked the trial judges when we enter our orders quieting title, that they accept the order quieting title, the certified copy, as well as any deed of confirmation that we may do, to accept those recordings without payment of transfer tax. For about, I'd say 15 years, not a single judge questioned it. The Philadelphia Department of Records accepted them, and even the Commonwealth of Pennsylvania, because don't forget, in Pennsylvania, if you do a normal real estate transaction transferring property, 3% goes to the city of Philadelphia and 1% goes to the Commonwealth. So they have an interest in this transfer tax. Trying to save the Tangled Title Fund money, we tried to get the orders, and you'll see our form orders say without payment of transfer tax. You can still do that, and I would encourage you to include that language, especially if you're unwinding a fraudulent conveyance, okay? The notion being that in order to put the parties back in the position of where they were before the fraud occurred, none of these deeds would have been recorded, the fraudulent deeds, right? And typically what you see in a fraudulent deed, it's a $1 conveyance, and they try to get out of paying the transfer tax in the first place. How unfair would it be to now, to quiet the title, put the title back into the name of the proper party, and now you're charging them transfer tax to do that? So typically you can get away with it. Where we have not gotten away with it are in the lease purchase agreements. Because the notion has been that if the lease purchase had been effectuated, okay, the end result would have been a deed, right? There's no dispute that if I went down there with a deed that I prepared from a lease purchase and went to record it, I'd have to pay transfer tax, because you're conveying title from one non-related party to another, presumably, whatever it is, no exception, you pay the transfer tax. My argument was always that if you put the party, the VIP client, into the shoes where they had to file an action to quiet title, and ultimately they were defrauded because they did not get their final relief, I argued they shouldn't have to pay transfer tax. For a very long time, the Department of Records and the Commonwealth agreed with me, but recently, especially the Commonwealth, they wanted their 1%. So I fought them. I said, look at the court order. They're like, we don't need to respect an order of the Common Pleas Court in Philadelphia. I'm like, well, that's news to me, but okay. Ultimately, because the transfer tax was small and the Tangled Title Fund does have the money to pay it, I think we decided we would just pay it if questioned. But I'd still, listen, use our proposed form of order, try it. The judges don't care. The judges are happy to accommodate the request. The Department of Records, I mean, I guess they'll
record anything. It's revenues pushback. What I'll say is that in doing this, which you should do is, one, make your client the correspondent on the transfer tax documents, and two, alert them and tell them if you receive some form of notice of delinquency for these transfer taxes, that they should reach out to VIP immediately so that we can get the payment.
I usually, by the way, this is just my preference. I usually make myself the correspondent on those transfer tax certifications, largely because the client doesn't even know how to prepare it typically. So I prepare it, I make myself the correspondent, and then I deal with the Department of Revenue and the Commonwealth. And, listen,
We're not making, you don't have to
you
do
don't
that.
have
You
to
don't
do
have
it.
to do
You
that.
don't have to do it. The only reason to do it, as Mike said, is if you name yourself as the correspondent, if there is a problem and they reject it or they're demanding their transfer tax, you'll at least be notified, and it won't go directly to the client. The client may not realize it. So just keep that in mind. If you have a question about it or you're concerned about it, you don't have to put it in the order. I'm just suggesting, especially if it's a fraudulent conveyance, you definitely want to do it. Any other questions before we end? You can always email. I think my email is somewhere on this.
You can always ask me for Bob's email.
Right.
I'm happy to give it out.
Anything else? Anyone?
Thank you.
Thank you so much.
Thanks.